Another scenario for today. Your company is involved in a lawsuit. It's important litigation. You want the best firm around. So you call a big law firm, a firm that's in the Am Law 100. You look over the retainer agreement. It says they will provide detailed invoices. They cannot wait for approval of every item, but will act in the best interest of the client. And the hourly rates, while high, seem reasonable for a quality firm. You're told that the other side has no chance. The case proceeds more or less as normal. There's a motion to dismiss, discovery starts up. You hear that the case is about to settle. And then you get an insane bill. Partners billing at $1,650 per hour without any description of what they are doing. An attorney billed $25,000 for 20 hours in a single day, with the only description being attention to discovery. And that brings us to our topic for the day. Today, we're going to tackle the overbilling practices of big law firms. And while many argue that smaller firms can provide better value for most companies and most cases, we're going to look at some billables from an actual case involving Twitter's case against Elon Musk that became public. Let's get into it. Let's start by addressing the elephant in the room, big law. Big law refers to the largest and most successful law firms that represent Fortune 500 companies and have offices scattered across the globe. These firms are known for their prestigious reputations and heavy billables. And, let's be frank, for massively overbilling their clients. To start, big law firms bill their clients by the hour. There is nothing improper about this in principle. An attorney works an hour and bills a certain amount of time. My firm bills by the hour for certain matters. However, and let's be honest about it, hourly billing incentivizes inefficiency. The longer a task takes, the more money that the firm makes. So when you sign up with a law firm on an hourly rate, you are somewhat at the mercy of billing attorneys. Now, at a law firm like mine, there are factors that are balanced against that. We have a reputation in our community and among other attorneys. If we overbill a client, that will spread like wildfire through our community and our referral sources, which will hurt our bottom line way more than a bit of extra billings is worth. In addition, there are only so many attorneys at a firm like ours, so there's a maximum number of hours that can be billed. These checks and balances do not exist at large firms. Frankly, big law firms, especially Am Law 100 firms, by definition, have reputations for winning high-stakes cases. Lots of them. They spend tens of millions of dollars a year on marketing and maintaining that reputation. And they get complaints about billing all the time. They just know exactly how to deal with those complaints from a marketing perspective. Similarly, large firms have tons of attorneys. So if they want to, they can literally bill 30 hours on a single file, maybe even a single matter at a time, or more. In the example I'm going to show you in a minute, a large firm billed more than $400,000 in a single day. And that is the other issue. Big law firms may also overstaff cases, meaning more lawyers are assigned to a case than is necessary. This increases the bill because each lawyer charges for their time, which can sometimes result in routine tasks being billed at exorbitant rates. That's not to say that all big law firms intentionally drag their feet, but it's pretty clear that billing by the hour and having an enormous law firm with hundreds or even thousands of attorneys that can bill creates some pretty perverse incentives. This is the billing sheet that made its way around Twitter. It shows billing from a single day of the firm that prosecuted Twitter's case against Elon Musk, the one to enforce his offer to buy Twitter. This billing sheet shows some absolutely crazy entries, and I am not talking about the hourly rate. A lot of the lawyers bill at more than $1,000 per hour, which might seem shocking. But if you're working with a big law firm, that goes to territory, and that's not the issue. The issue is the description of the tasks and types of tasks. For the one day encompassed by this billing record, the total amount billed was more than $450,000. There was more than $70,000 billed for document review. That includes one guy who billed 20 hours for attention to discovery for $25,000, but it's not counting records where document review was part of what was listed. If you count those, you're over $200,000. There is $72,504.50 for entries with no description at all. Pure and simple, this is not acceptable. This is most likely a large firm overbilling a corporate client to the entire disadvantage of shareholders and other employees. I'm not going to go over how this happens, but the reality is that if Twitter had employed a smaller firm, a firm like Bartlett Beck or Sperling and Slater, both firms that I have a ton of respect for, they would have gotten the same result and spent about 10% of the amount that they spent with the monster New York firm they ended up working with. So, where do small law firms come into the picture? And why might they be a better choice for many companies? To start, when I say a small firm, I am talking about a firm with between 15 and 100 attorneys. Small law firms are often much leaner. They typically have fewer attorneys and lower overhead costs, which allows them to offer more competitive rates. And because of their size, they usually more flexible and provide more personalized service. In addition, the attorneys in small firms often handle cases from start to finish, which helps them develop a much deeper understanding of the case, the client's business, and the specific needs. In other words, an attorney that handles your case is likely handling a few other cases and not 10 or 12 other cases. He or she will review a document once, make notes, and remember it. This differs from a large firm where a document review attorney is going to be handling a ton of different cases and will make notes that another attorney who writes a brief or does work will have to review. There are all sorts of other process issues with large firms versus small that can lead the small firm to be more efficient, effective in representation. Many small firms also embrace alternative billing methods such as flat fees, monthly flat fees, contingency fees, or hybrid arrangements. Generally, this leads small firms to operate in a much more efficient manner. These methods can be more predictable and transparent, helping clients budget for legal costs and avoiding unpleasant surprises. Now, the counter to this is that a smaller firm just could not do the job that a larger firm could. This counter is nonsense, at least for every case that I've ever looked at. As background, I have litigated numerous complex intellectual property cases. I have litigated against mega firms and smaller firms. I have litigated against excellent attorneys from mega firms and from the smaller firms. If the firm has an excellent reputation and has the personnel to handle your case, you are going to get just as good a result from a quality small firm as from a larger firm. Seriously, go and compare the records in complex cases of an excellent 30-attorney firm against the record of an AmLaw 100 mega firm. In many cases, the smaller firm will have a better record. Do not let anyone tell you different until you've looked yourselves. You do not have to tolerate ridiculous billing practices to get good results in high-stakes litigation. I want to be really clear. Not every big law firm overbills, and not all small law firms are paragons of efficiency. However, if you hire a large firm, you are much more likely to get hit with a monster bill. Consider the unique needs and budget of your company, the complexity of your legal issues, and the potential value of different billing methods. And remember, a higher price doesn't always mean better service or outcomes. One way to avoid that is just to not do business with a mega firm. The number of cases where you need a mega firm is exceedingly small. Like I said earlier, I don't know of any. So if you don't want to get hit with a bill like the one we looked at earlier, just don't hire them. In addition, if you work at a corporation and you are hit with a bill like this, you need to do two things. First, and this will make me extremely unpopular with my fellow legal professionals, simply refuse to pay it. If there are entries like attention discovery and entries with no description that add up to tens of thousands or even hundreds of thousands of dollars, simply tell the firm you're dealing with you're not going to pay it. Second, you need to identify the employee or employees that are responsible for hiring the firm, and you need to either retrain them or get rid of them. If it's a culture issue at your firm or they were hiring a mega firm because that is the safe thing to do, you need to retrain them on a different culture. On the other hand, if they hired the mega firm due to an expected quid pro quo in the future, you need to fire them, as they are making decisions to advantage themselves and not the company or shareholders. And that's it for today, folks. I hope this video provides some insight into why big law is usually not the right decision. Remember to hit the like button if you found this helpful, and share your thoughts or experiences in the comments below. And as always, thanks for tuning in.